is now saying that a woman who is married, meaning that it's also given another category.
Okay.
And for example, one of the reasons why we're arguing for deletion is also for us to ensure that we don't have ambiguity in the Constitution that could cause the kind of problem that we have, even given the intervention by Senator Yerima.
Okay.
If you have Section 29A, which is already saying full age is 18 and above, why do you need another section determining a particular gender who can be called full age? Because if you look at 29.4b, it's talking about married woman. And a married woman could be 11, because we know that there is we get young women married off in Nigeria at the age of 11, at the age of 9, and it's not just peculiar to the north. You know, we have had, as a women's rights organization, we have even had a case like that in Lagos, you know, of a 70-year-old man attempting to marry off a 13-year-old girl. You know, so in a country where you have that kind of instance, it will be it will not suit us if we have a section in the Constitution that can be misread in that line. Okay. Now, but that section in particular, is not addressing child marriage.
Exactly.
It's addressing the issue of renunciation of citizenship.
Okay, but when you, pardon me for buttoning,
yes.
When it says any woman who is married shall be deemed to be of full age.
Yes.
Deemed in law, what does this mean? Because, I mean, I heard people say deemed means it's not actual, but taken to be so.
Yes, it's taken to be so. It's seen as an adult.
So you don't necessarily have to be, what, 18? Don't they have a valid point if they say you don't necessarily have to be 18? Or
yeah, but that's what it's saying, actually. What it's saying is that what you need to be qualified to be a full age person, it's marriage.
So now, your group wants...
that brings out the issue of marriage, which means you can be, if you are 18 and you are married, that's fine. You can also be 11 and you are married, and you can be 13, just as the case of the Egyptian lady married by the said senator.
That is the part that your group wants.
Yes. So, and it's a part because we feel that it's ambiguous.
Okay.
We feel that it contradicts in a way what has been asserted in the first proviso, which is Section 29.4a.
One would wonder, you're a lawyer. This portion of the Constitution has been, it's not as though it was just inserted with the last amendment, it's been there.
Yes.
One would wonder why your advocacy group or other groups haven't pursued this before now. I mean, that part of marriage, for instance, there's a marriage act that says the age of marriage is 21, not even 18. Yeah. So how...
But the issue has been on, not even, not this year, since 1999. When that section has been there. So people have been advocating for the change in that section dealing with citizenship in the Constitution of Nigeria. Gender advocates, we have found that very discriminatory, and we have been calling for a change. I must explain that, yes, we have a child rights law in Nigeria, and that's where oftentimes when you make arguments, there's been a lot of issues with children in Nigeria. There's been a lot of violation and abuse of the rights of the child. And of course, the question of what age also it's important. The Matrimonial Cause Act followed the Nigerian Marriage Act, which puts the age of marriage at 21. The Immigration Act puts at 16. You know, so we have, so in terms of what's the age of majority in Nigeria, there are contradictions out there. But my point is also that the Constitution is not supposed to be addressing the issue of marriage. I think that's all that lost you. In NACAFA, if you look at the exclusive list of the Constitution, it actually doesn't allow the National Assembly to make law which is related to customary and Islamic marriage. So the argument of the senator actually, it's actually unnecessary. And I think that what he has been able to do is to distract the focus of that argument. That discussion on that day was supposed to be based on discussion of renunciation of citizenship. But be that as it may, what Senator Yerima has actually brought out is the fact that there's a need for Nigerians to be much more aware of what is happening in the Constitution. You know, there's a need for us to understand clause by clause section of what the Senate were voting for on our behalf. So the good thing about that is that it has brought that to the public view. And people have started debating. So what are the other issues that they were talking about?
Now, you'll help us redirect them because you're a lawyer. You've been in this. You were on the floor of the Senate, as a matter of fact. Now, it's clear, just as you've said, this is not about child marriage, that particular section.
Yeah.
Now, for those who think, okay, even if that section is not about child marriage, it's about renunciation of citizenship rights, they want to know, where then, if they want to talk about child marriage, which this incidentally has brought up somehow, they then have to focus on what? The age of marriage law, which has been in existence since, is it 1956?
1990.
Yeah, it's in the law of the Federation of 1990.
There's one for 1990.
Yeah.
Okay.
So, well, there's a problem with our laws anyway, and it's also part of what we can't clamor for, that there's a need for a general review of the Nigerian law. The Immigration Act has 16. Under Criminal Code, we are between 12 and 17 as the age of majority. And if you look at the child rights law, it says 18. Nigeria,
But some say 16. Age of marriage law is
yes,
16.
because you know the child rights law, after being passed at the federal level, has to go to the states. And
So
as of today,
it's
there
under
are
the
24
exclusive
states.
list
Yes.
of the states.
Yes. So,
Can the National Assembly legislate on that?
no. There was a National Assembly legislation on child rights, and that's why we have the federal child rights law. But as it is in Nigeria, it can only, because of the federal system, it's also restricted to the Federal Capital Territory. So, which means other states have to adopt and do it in their own way. I'm aware that Ogun State, for example, had a child rights law as at 2003, and some few months ago they said no, that there was some inconsistency in the law, and they did a public hearing last Friday, you know, to look at that child rights law again. So, which means, and people are also tweaking it to suit their own circumstance. So we have like 24 states with different child rights law, with
Different zones, as a matter of fact.
Different zones,
because
yes.
some talk about the customary marriage law. That is different. Some say it operates in the southeast and some part of the south-south, excluding, I think, Delta and Edo. At the time, they were under the southwest. And so that didn't apply to them.
Yeah, so
then you have
there are a
well.
lot of laws dealing with different ages. So I think that that's a problem, and that there's a need for harmonization of those laws. In some countries, what they do is to have a uniform age of marriage. But you see, the argument also for Nigeria is that if we have signed international conventions, which puts age of marriage, the UN Convention on the Rights of Child, which puts age of marriage at 18, of a majority of a child, that's 18. You know, and we have also signed the Protocol on the Rights of Women in Africa, and also the African Charter, and also the African Protocol on the Rights and Welfare of the Child, which talks about the majority at age. We can't lower the standard, not even for a country like Nigeria. The recent UNICEF report is clear to say that we have most of our children on the streets and they are illiterate, which shows that there are a lot of issues related to child marriage. Majority of these are women, they are girls, and the girls that are married off, who because of marriage cannot go to. So the discussion there with that 29(4)(b) is that it can be misrepresented. That is why people are raising the issue of child marriage. So let me just tell you the connection between that 29(4)(b) and child marriage discussion.
Okay.
The connection is that, yes, on the face of it, it's addressing the issue of citizenship and renunciation of citizenship. But you can get a judge who will say, yes, okay, so where do we find age of marriage? So then goes into 29(4)(b) and use that as a way to justify child marriage. And it can also be read beyond child marriage to have a lot of other effects, that somebody who is not 18 can vote, can obtain a driver's license.
That's the implications.
Yes, so it has
it's not properly spelled out.
Exactly. So it has beyond the question of child marriage, it has a lot of other implications.
Okay,
It means you can vote and be voted for, a young girl, as long as you are married.
Yeah.
If you are deemed to be of full age, that means you can vote. You know, so there are a lot of. So we need to expand the discussion so that we're not just taking it up and say child marriage, and we get ourselves involved in the discussion around what does Islamic law say and all that, which is where Senator Yerima is trying to push out to. And I don't think that we would help people who are working on the Constitution if we take that argument.
So at the end of the day, we're trying to focus on the girl child now.
Yeah, well, yes.
The right of,
Partly.
but partly. But let's just say that portion is, let's say the Senate rescinds and decides to knock off that portion. How does that solve this issue of disparity in the marriage age of especially the girl child?
Well, that's issues. That's an issue that we need to deal with at the level of harmonization of our laws in Nigeria. So, you know, because the Constitution is the supreme law, if the Constitution gives legitimacy, even if we try to harmonize it